A very good afternoon to our viewers and participants and our esteemed speakers. A warm welcome to everyone joining us for today's live legal talk show under the broader theme of Regulatory Framework for Doing Business in Indonesia and India, Navigating Opportunities and Challenges. I am Pranshu Singh, Senior Associate at Hammurabi and Solomon Partners, New Delhi, India, and it's my privilege to moderate this insightful discussion on two of the world's rapidly emerging markets, India and Indonesia. Today's session features an esteemed panel of legal experts. They bring with themselves a wealth of knowledge on key factors shaping business growth and success in both the jurisdiction, offering valuable insights into bilateral trade and investments, agreements, regulatory framework, trade policies, and cross border compliances. Hence, ensuring a well rounded discussion on the challenges and strategic considerations that is necessary for businesses looking to enter and expand in India and Indonesia, respectively. Now, allow me to introduce our distinguished speakers for today. We are delighted to have a distinguished guest speaker, His Excellency Mr. Sandeep Chakravorty, Indian Ambassador to Indonesia. We welcome you, sir. We have esteemed panel speakers, Mr. Anil Tiwari, partner Hammurabi and Solomon Partners, India. We have Ms. Jeany Tabita, partner Bagus, Enrico and Partners, Indonesia. We have Mr. Ashutosh Das, partner Hammurabi and Solomon Partners, India. And we have Ms. Maria Bunga, associate Bagus, Enrico and Partners, Indonesia. A very last minute update before we dive into the session. Ms. Sweta Bharti, our managing partner, and Ms. Svadha Shankar, our moderator for the event, will not be able to join us today owing to some last minute commitments. Hence, allow me to provide a brief introduction to our firm, Hammurabi and Solomon Partners, and take this session forward in the capacity of a moderator. Thank you. So, our firm Hammurabi and Solomon Partners is a leading full service law firm established in 2001. Over the years, our firm has built a reputation for providing comprehensive legal services across a wide spectrum of practice areas. Core areas of expertise includes corporate advisory, mergers and acquisition, data protection, compliance, litigation, arbitration, insolvency and bankruptcy, public policy, and real estate. We take pride in a team of 100 plus professionals, including 18 plus partners pan India. They bring with themselves legal expertise to the table. A team operates across multiple regions in India, including Delhi, Mumbai, Bangalore, Jharkhand, Ahmedabad, Chennai, and Hyderabad. A firm strives to be at the forefront of legal innovation and also provide high quality legal counsel and representation in complex legal matters. I would also take this opportunity to invite Mr. Bagus, Managing Partner, Bagus Enrico and Partners, to introduce the firm to our audiences. Mr. Bagus, over to you, please.
You are on mute, sir.
Sorry, Your Excellency, distinguished guests, ladies and gentlemen, it's my distinct honor to welcome you all and to express our sincere appreciation to His Excellency Mr. Sandeep Chakravorty, Ambassador of India to Indonesia, for his gracious presence and support. His endorsement underscores the shared commitment of our nation to deepen bilateral cooperation. We also would like to extend our gratitude to our co-hosts, Hammurabi and Solomon, one of India's leading law firms, for partnering with us on this important initiative. Our ties with India are long-standing. We have had the privilege of working closely with Indian clients, investors, and legal professionals. This collaboration has enriched our practice, and we see immense potential for further collaboration, especially in today's evolving regulatory landscape. Today's seminar, Regulatory Framework for Doing Business in Indonesia and India, Opportunities and Challenges, is both timely and essential. As two of the Indo-Pacific largest economies, India and Indonesia play pivotal roles in shaping regional trade and investment. A clear understanding of our respective legal frameworks is key to unlocking this potential. Such forum foster dialogue, build trust, and pave the way for stronger economic ties. Continued support from both government is vital to ensure regulatory clarity and institutional cooperation. It is why we especially encouraged by Ambassador Chakravorty's support, which reflect a shared vision for deeper engagement. Regarding Bagus Enrico and partner, since its establishment in 2009, we have consistently ranked by leading legal publication, including the Legal 500, IFR, Chamber of Partners, Asia Business Law Journal, Hukum Online, Asia Law, and others. Our lawyers and practice group are consistently recognized as among Indonesian top performers, particularly in corporate M&A, banking and finance, TMT, and real estate and construction. This track record not only gives us credibility, but also confidence to support this initiative. We are proud to bring this experience to support Indian business navigating Indonesian dynamic market. We trust today's discussion will enhance legal understanding and promote greater commercial success for all stakeholders. So at last, thank you for your presence and participation. We look forward to continued collaboration between our two great nations. Thank you very much. Back to you,
Thank you,
Prabhu.
Mr. Bagus, for that introduction. That was quite insightful. That helped our viewers and participants to gain insights into the firm functioning. Now, before we proceed with this session, allow me to introduce a distinguished guest speaker for today's session. We are honored to have a remarkable individual with us, and it gives me immense pleasure to welcome and introduce His Excellency Mr. Sandeep Chakravorty, the Ambassador of India to the Republic of Indonesia. Mr. Chakravorty is not only a highly successful diplomat, but a shining example of dedication, prudence, and service. Over 3 decades of his distinguished career in the nation's service, he has devoted himself to the principles of global diplomacy, international cooperation, and public service. Let me take a moment to reflect on the breadth of his experience. He carries with him a wealth of experience from his past assignments. Having joined the Indian Diplomatic Service in 1996, he has occupied some of the most important and strategic role in India's diplomatic system. He has been India's ambassador to Bolivia and Peru, a consul in New York, and served as the Deputy High Commissioner in Bangladesh. His skills and commitment have also led him to India's mission in Spain and Colombia, where he was instrumental in enhancing bilateral relations and advancing India's strategic interests, demonstrating his global outreach and versatility across nations. However, his contributions do not end here. What is particularly inspiring of Mr. Chakraborty's journey is his strong foundation in social and environmental causes. Prior to joining the diplomatic service, he has also spent more than 5 years working on sustainability and environmental projects for non-profit organizations in India. Mr. Chakravorty has a master's degree in advanced studies in international and European security from Geneva University, a master in sociology, and a postgraduate in forestry management. This rare combination of environmental, social, and international knowledge gives him a rare and invaluable perspective on the challenges and opportunity facing our world today. And if all of this were not enough, Mr. Chakraborty has recently authored a book named International Relation and Diplomacy Primer. This insightful and accessible handbook is a gift to all who wish to understand the intricacies of international relations and diplomacy. As we gather here to learn, share, and to grow, it is my great pleasure to invite to the webinar a visionary diplomat and an inspiration to all of us, His Excellency Mr. Sandeep Chakraborty, to address the viewers and share his valuable insights. Mr. Chakraborty, over to you, please, sir.
Thank you, Svadha, for that very generous introduction. I was wondering if you're talking about me or somebody else, but thank you very much. And I'm delighted to join this webinar on the regulatory framework for doing business in Indonesia and India. Since I'm based in Indonesia, and I would like to focus on the Indonesian aspect of the relationship, because and how we fare as far as India is concerned. As all of us know, Indonesia is a large country. It's about 280 million population. It is the world's third largest democracy. That sometimes is not understood by most people. It is after India and US. Indonesia is the world's third largest democracy. That is an important factor on with regard to how the country deals with issues, how issues are resolved, how the regulatory framework operates in Indonesia, and also the political risks involved and stability within Indonesia. The per capita income of Indonesia is about $5,000. So in some ways it is double of that of India. So double per capita income as compared to India means greater disposable wealth, and then that has an influence on purchasing power of citizens of Indonesia. Middle class is about 60 million, and like India, it's a young country. It's enjoying a demographic dividend. But more importantly, from the market's point of view, it is the gateway to Southeast Asia. It is a population of about 650 million. And also Indonesia has a network of FTAs and trade agreements with several countries. It's a member of RCEP. It is, I think, also a member of CPTT. And so that opens up opportunities for investors who want to establish in Indonesia. There is, I think Indonesia has FTAs with 22 countries, and including being part of ITGA with India, which is presently under review. So ITGA is an important framework for Indian businesses who deal with Indonesia, and it's important to note that it is under review because it's an old agreement, and it has become outdated. The areas in which we have concessions, those are hardly now being traded. New commodities are being traded, new products are being traded, and those are not covered under the purview of ITGA. So the review is happening this year. Hopefully, we will have a more robust ITGA in the coming year. Indonesia is also undergoing review reforms. It's opening up. It is seen in the omnibus law, the online submission system, and there is a revised positive investment list. And these are meaningful steps aimed at simplifying licensing, enhancing transparency, and opening up sectors to foreign investment. Foreign investment is open, 100% investment is open in most sectors except a small negative investment list. And every day we are hearing that new businesses are opening up to foreign investment, particularly in ICT, health, transportation, agriculture, mineral resources, construction. These are the areas where foreign investment are welcome. The president, since he took office in October of 2024, has come out with an Astachita policy. It is eight priority areas where he wants to make movement, where he wants foreign investment, where he wants to make a difference in Indonesia. So this includes manufacturing, trading, education, construction, mining, and he wants to also embark on a green transition, more opportunities for renewables. So basically, Indonesia is now in a process of what I would say churn, in the sense it is undertaking reforms. It wants to it has many social sectors to address. It has many programs to address the bottom half of the pyramid, And those I think are also impacting its economic growth, because last quarter growth was below 5%, but the sentiments are positive, and the president has said by the end of his term in 2028 9 Indonesia will register a growth of 8%. So that is the optimism we have, and Indonesia and the government is working towards that. We are the third or the fourth largest trading partner, depends on yearly statistics. But as you may be aware, Indonesia has enormous surplus. In 2023, it was $17 billion. In 2024, it was almost $15 billion. So we have an issue of trade barriers, of NTBs, and also tariff barriers, in the sense that Indonesia only committed to about 54% of tariff lines to the ITGA. So we give more tariff access to Indonesia rather than Indonesia giving to us. So there is some disparity, and I hope that will be addressed. Also, there are new barriers, in the sense which are affecting trade and investment. One of them is TKDN, which is the local content rule. 40% TKDN is enforced, so that sometimes creates problems. And there is a elaborate system of quotas and licensing. So India of the 1990s and early 2000s, where we had not yet done away with our quota and licenses, that system prevails to some extent in Indonesia still. So that works as a barrier. So the OGL system is not as robust as in India. So it is difficult sometimes to obtain licenses, and there are quotas, and that impacts trade, and also it impacts investment, because companies would first like to trade. They would like to understand the market, and when they are assured that there is a market, then they invest. But if you are putting barriers, and if you say that no, you can only import a certain number of products per year, then that harms investment plan. So this is the general scenario that is affecting trade and investment sentiment in Indonesia. Having said that, there are over 100 Indian companies present in Indonesia with offices in Indonesia. Many have manufacturing, others are representative office, but they are doing business in Indonesia, and that number is growing. That's a very healthy indicator. Every now and then we are hearing about Indian companies wanting to establish in Indonesia, and that is a positive development. There are processes which allow foreign companies to establish quickly in Indonesia. The process of granting permissions and all is easy. There is an investment agency here called PM. They are very friendly. They support in foreign investors. They have an India desk, and often we take our issues and problems to them, and they do provide solutions. So I would like to strongly recommend BKPM for being a friend of Indian investors. And whenever there are issues, we have meetings with them. They resolve our problems. And any interested investor, we always recommend that they meet with BKPM and share their investment plans. Also, incentives are available. There are special economic zones in Indonesia where tax holidays are available. Many are negotiating those and want to establish themselves in these tax holiday special economic zones. There is a new development in Indonesia with the establishment of the Sovereign Wealth Fund, which actually has become a holding company of state-owned enterprises. More than 800 state-owned enterprises have been brought under this Sovereign Wealth Fund called Dhanantara. But what is interesting is that Dhanantara has funds which they want to invest along projects. So if there is an Indian investor which is looking at investing in big projects in let's say in the mineral sector or infrastructure or or ports or airports or in mining, then you could collaborate with Anantara. Recently, Qatar has agreed to co-invest with Anantara in projects in renewables, but that option is available to even Indian investors, particularly if you are looking at areas such as agriculture or manufacturing, then Dhanantara would be interested. Um, I don't want to get into too much of detail because uh, you know uh, uh, there are a lot of variation, lot of intricacies, depends on what you want to do. But my point here is that Indonesia is a big economy. It is growing at least 5% a year. It has a sizable middle class. People have disposable income. It is well located in the Indo-Pacific region. It has FTAs with many countries. In fact, we are also looking at a bilateral trade agreement with Indonesia, which may further open up sectors and remove tariff and non-tariff barriers for Indian companies. So Indonesia is a very attractive trading and investment destination. The rule of law prevails to a large extent. There is redressal of issues. There is a robust legal system. There is a hand-holding organization, which is the BKPM. There is also a Ministry of Investment. They also do troubleshooting. So the investment climate is positive. But at the moment, due to geopolitical and other issues, maybe companies are holding their investment plans because I'm alluding to the tariffs. So that could be one reason why companies are holding back on their investment plans. But I would rate the Indonesian prospects from moderate to high, and I would take this opportunity to invite Indian companies to look at Indonesia, to come to Indonesia and invest in Indonesia, because this is a major country in the world, and it is rich in resources, and it is targeting a growth of 8%. Thank you.
Thank you, His Excellency, for that insightful address. It is a pleasure to have you for the webinar, and we extend a sincere thanks for that insightful brief overview of the India Indonesia bilateral relation. I'm sure our speakers are going to deal with the issue and the topics in detail in further webinar addresses. So it has been honor to have you with us. Thank you again. Now let's move ahead with the webinar. Before we dive into the conversation, allow me to give a brief overview of the concerned topic, that is regulatory framework for doing business in Indonesia and India, opportunities and challenges. So, in the era of increased global interdependence, emerging economies such as India and Indonesia are assuming greater prominence. As already addressed by His Excellency, the market that both the jurisdiction holds not only in global trade ecosystem but also as pivotal jurisdiction for cross-border investment and regulatory convergence in Indo-Pacific region. Two of Asia's biggest emerging economies, India and Indonesia, they are connected not only by strong cultural ties but also by expanding trade and investment ties. Both the countries are negotiating dynamic regulatory environments that are majorly influenced by economic reforms, multilateral interactions, and changing international priorities as strategic partners in Indo-Pacific area. Now, the aim of this webinar is to examine how the legal and regulatory frameworks governing the employment laws, cross border trade, foreign direct investments, and dispute resolution procedures are changing in Indonesia and India both. We are seeing a complicated but, however, promising talks regarding the India Indonesia CECA, that is Framework Agreement on Comprehensive Economic Cooperation, the Asian India Free Trade Agreement, there have been continuing talks and growing significance of the local currency standard system too. So this webinar is offering both a mixed opportunity and a challenge for investors and companies in both the jurisdiction. Indonesia's regulatory system, on the other hand, has sought to simplify licensing processes and promote the foreign capital by cutting down on sectoral inhibitions and harmonizing the labor laws. But companies also need to deal with subtle issues like adherence to local content rules, the data localization policies, and conflicting regulatory bodies. And understanding of these regimes is not only critical for compliance, but also for developing strategies that are consistent with national priorities, investors' aspiration, and sustainable business objectives in both the countries. Our esteemed panel will offer comparative analysis of the foreign investment policies of both the nations, emphasizing again the prospects for expansion as well as the difficulties that company must overcome with caution and strategic planning. We look forward to a productive conversation. Now, let's dive into the conversation, hear from our expert panelists, and explore the intricacies of cross-border business between India and Indonesia. Let's begin the session. I call upon Mr. Anil Tiwari, partner Hammurabi and Solomon Partners, to enlighten our viewers. How is the ASEAN India Free Trade Agreement, the AITIGA, shaping India Indonesia trade dynamics? Mr. Tiwari, over to you, please.
Thank you, Ms. Pranshu. So, the trade relation between India and Indonesia, the first milestone was Trade Agreement of 1996, where the items which were to be exported and which were to be imported were identified. So that was the first milestone. Thereafter, the Trade Agreement of 1978 tried to remove the imbalance between the trade of the two countries. And thereafter, in 2005, we found both the countries signed an MOU within the broader framework of comprehensive economic cooperation. And then came the ASEAN-India Free Trade Agreement. So after ASEAN-India Free Trade Agreement in 2010, now India and Indonesia are a free trade agreement. The ASEAN-India Free Trade had actually given or rather facilitated the trade volumes between the two countries and also increased the investment flow and has given economic prosperity to both the regions. As mentioned by His Excellency, Indonesia is now the third largest exporter and the largest importer for India in economic within the ASEAN countries. The trade between India and Indonesia in the financial year 2023 to 24 stood at 29.39 billion. Indonesia is also 36th position in terms of FDI equity inflow into India. So to sum up, the ASEAN-India free trade has really given a major boost to the trade relation between both the countries, and it's really moving in a right direction as it is ever increasing.
Thank you, Mr. Tiwari, for those insights. Now I would call upon Mr. Ashutosh Das, partner Hammurabi and Solomon Partners, and I put forth the question, Mr. Das. In your opinion, what are the legal and diplomatic challenges that are holding up the India-Indonesia CECA, and how could they impact the investor confidence? Over to you, Mr. Das.
Thank you, Pransu, and I really thank His Excellency before I put it my views to it, because he has really summed up very well. And coming back to your question, in my opinion, to put it simply, Indonesia and India are not moving ahead because they are yet to find an equilibrium to accommodate both countries' geopolitical aspiration as well as economic aspirations. So the moment we get to that stage whereby we create that balance, these trade talks, which are kind of going very slow or rather not happening anything, will take a faster route. So in my opinion, we need to find a place, and particularly in this current scenario, whereby because of so many development triggering out of USA, the entire global supply chain and the entire business arrangement is going through a reset. And India and Indonesia, both the countries, they have greater opportunity to create a situation whereby mutually, not only they can help each other and get a very good share of this reset, even going forward, they can offer some of the solution created by this reset. So again, coming back to pointing what legal and diplomatic hurdles, in my opinion, these hurdles are very small hurdles. The moment both the sovereign countries, both the governments, and as His Excellency has already kind of pointed out, these are big democracies. So they have internal audience as well as external audience to cater. The moment we find a solution to these situations, we will be moving ahead, and hopefully sooner the better. I'm kind of keeping my fingers crossed. And here, uh, even the legal firms like us, and currently both the legal firms interacting here, they can play a role. So all of us, we do have a role to play to fast track this kind of interaction between the government so that we find a place which is mutually beneficial. Yeah, over to you, Pranshu.
Thank you, Mr. Das. That was quite a balanced perspective into the existing geopolitical scenario of both the jurisdiction. Now, moving on to the next slide, I would call upon Ms. Jeany from Bagus, Enrico and Partners. She's a partner there. I put forth the question, Ms. Jeany, to you. How can bilateral trade agreements like AITIGA, that is Asian Indian Trade in Goods Agreement, can be developed to assist in rise of sectors like digital trade, AI, and fintech between Indonesia and India both? Over to you, Ms. Jeany.
Thank you, Pranshu, for the question. So we have listened to the brief earlier from Mr. Tiwari and Mr. Das, and we see here the major goods that India buys from Indonesia are mostly oils, waxes, and lots of minerals. And as discussed by His Excellency earlier, India is one of Indonesia's largest trading partners in ASEAN region. And the numbers are encouraging. However, the trade balance still shows some room for growth. And bilateral agreement like ITIGA, multilateral agreement actually, have focused on trade in goods. Yeah, but in its current form, it doesn't directly address the digital economy issue. So there's a strong potential to expand or to complement these legal frameworks to support emerging sectors like digital trade, AI, fintech. These areas where India is already highly advanced. And to support deeper cooperation, I think both countries can explore like joint innovation initiative like regulatory sandboxes or talent mobility. We know India has lots of talents in fintech and AI, and ASEAN has moved ahead. Among the members, we have ASEAN Digital Economy Framework Agreement. So I think it's time for India and Indonesia to consider an independent bilateral agreement on digital economy partnership that specifically focus on digital economy. I think later down the line, we will going to discuss more on this. So the kind of agreement that will not only complement ITIGA, but also to create a more future ready to implement investment and innovation between the two countries. I think that would be my view, Ms. Pranshu. Back to you.
Thank you, Ms. Jenny. That was quite a experienced insight into the topic. Now, coming back to Mr. Das, I put forth another question to enlighten our viewers. After the termination of 1999 BIT between India and Indonesia, what legal protection and dispute resolution mechanism do investors use nowadays? Can you please shed some light on that? Over to you, Mr. Das.
Yeah, sure. So currently, the preferred one is the international arbitration. That's the best option available, which is widely favored and for resolving commercial disputes. But we do have other options available because for so many bilateral treaties, even if we have terminated, there are some sunset clauses which can be of help in case that particular company or the issue falls within that. Again, we do have a broader ASEAN-India framework agreement, which includes detailed dispute settlement procedures. So these are a few options available, but at present, the preferred one is the international arbitration, or if I can pitch few things from my personal opinion, I think the kind of webinar we are having, both the law firms can pitch in, because for the Indonesian companies, if they are working there with Bagus, they can have a partner, reliable partner for the Indian legal system. Same with the legal Indian companies for the Indonesian scenario, because even if you have to go through the local legal framework, you can have these reliable partners to help you out. So even this option is available, and particularly India opening up for the legal foreign legal firms, we are kind of going ahead and trying to accommodate other foreign legal firms so that they can have a familiarity with the Indian legal system. So even if we don't have a bilateral treaty defining the legal framework, we can have all these options to choose from. Back to you, Pranshu.
Thank you. Thank you, Mr. Das and Ms. Jeany, for that grateful insight. Now, moving ahead to the next slide and topic of concern, legal framework for investments. I call upon Ms. Jeany again to address the viewers with a short questionnaire. How can legal risk be avoided by investors while venturing into joint ventures in sensitive and restricted sectors in India and Indonesia? Over to you, Ms. Jeany.
Thanks for raising that, Ms. Pranshu. I think I would like to speak on the Indonesian side. And when discussing the regulatory framework on doing business in Indonesia, I will start with the two important key laws, the investment law and the company law. And in general, to start the business in Indonesia within the framework of foreign investment, it can be in a form of limited liability company or representative office. But before making the decision on investment, I think it's important to firstly assess and analyze some key aspects. Like, for example, the specific industry or business sector you'll be operating in, the structure of business model you want to implement, and the extent of your intended presence in Indonesia. And like, for example, will you have a significant customer base in Indonesia? Do you want to have local partners in Indonesia? Do you want to hold assets in the country? Something like that. And if the answer is yes, then you may consider to establish a limited liability company, or we call it PTPMA. So it's basically a limited liability company with foreign shareholders. And subject to your business line, later you have to find it through the Indonesian Industrial Code. So we have this business code classification. The total investment needs to be more than 10 billion Indonesian rupiah. It's around 650,000 US dollar. And the investment can come from capital or other financing sources like loans. Now, for a company with foreign shareholders, there's a minimum capital requirement of 10 billion Indonesian rupiah that must be fully issued and paid up. And this applies to all sectors, actually. And now to answer your question on how to avoid legal risks before entering a JV agreement, for example, we would suggest to know the foreign ownership cap first. So grab the latest positive investment list, and because it will tells you how much you can have, 50%, 67%, 80%, or if the sector is actually open 100% for foreign investor, then you can just go ahead to establish the company. But if the cap forces you to have below 100, like 50%, for example, then you have to set up a company with a solid Indonesian partner. And in that case, it's very important to vet your partner carefully, like check their license, check if they have ongoing lawsuits, litigation, if they have assets, what are the assets, and so on. And also don't forget to write your JV contract, of course, make rules on like transfer of shares, who can nominate the director, who can nominate the commissioners, how to approve business plan, how to distribute dividend, something like that. And well, definitely I cannot finish talking about the whole thing in few minutes, but that would be the main points I can address so far. Back to you, Ms. Pranchu.
Thank you, Ms. Jeany. That was quite insightful again. Related to the same topic, I would call upon Mr. Anil Tiwari to address few of her questionnaires concerning the Indian jurisdiction. Mr. Tiwari, how does India's FDI channels differ from Indonesian joint venture and representative office framework in real life? If you can enlighten our audience, please. Over to you.
Thank you, Pransu. So India provides basically two channels for FDI. One is automatic route and the other is through government approval. In automatic route, you need not take a prior approval from the government. However, India has set certain limits on the sector wise, that how much investment in a particular sector is allowed. While the government route is where the prior approval from the government is required, and these are basically reserved for the strategic sectors. So far as Indonesia is concerned, Indonesia has two modes of FDI, that is through JV or through representative office. So in JV, basically you have to choose a partner. In fact, in JV, the two entities combine their resources, their skills, their expertise to form a third entity or a project. So in JV, you have to be careful about choosing your partner, the kind of legal structure you want to opt for, and of course the regulatory requirements you have to meet. In representative office system, basically representative office system is basically used to assess the market and the clients through a local partner. So the limitation, the approval thing is not required, but the limitation here is that you cannot become a business entity. I mean, you cannot enter into a commercial activity for profit. So that is the limitation with the representative office system. So representative office is basically used to assess the market, the local market, to get acquaintances with the clients, the partners, for a full scale business investment in Indonesia. So that is how it works in both the countries.
Thank you, Mr. Tiwari. A short question that is emanating from the same issue, from the same topic, I would say. How are the Indian FDI entry modes different from Indonesia's sectoral foreign ownership restrictions in real life? If you can provide an insight into that too. Over to you.
Definitely. So basically, in India, as I mentioned, there are two routes. One is automatic, and the second is through government approval. So what the India has done, that they have fixed a limit on sector wise. Like for insurance, they allow 49% of FDI. In banking also, they allow around 49% of FDI. In some sectors like telecommunication, medicinal equipments, even 100% of FDI is allowed. Whereas in Indonesia, they have a positive list which allows the foreign direct investment up to 100%. So in Indonesia, either it is a positive list or a negative list. So either you are allowing the foreign direct investment, which is mostly up to 100%, or you are not allowing it. So mostly, I mean, in telecommunication, in transportation, Indonesia is allowing 100%. They are in positive list and they are allowing the foreign direct investment. Whereas in some strategic sectors like chemicals, weapons, gambling, etc., they are not allowing at all. So things are moving. Now think they have come up with an omnibus law, and more sectors are opening up for foreign direct investment, and they are coming into positive list.
Thank you, Mr. Tiwari, for that comprehensive insight. Now, moving on to the next slide, legal framework for investments in Indonesia. I would call upon again Ms. Jeany to enlighten our viewers on how significant are SEZ advantages in both nations for foreign investors, particularly in manufacturing and technology industry. Over to you, Ms. Jeany.
Thank you, Pransu. So special economic zone provides a huge advantage, not only for foreign investor, but also local investor. Let me quickly address what's on the slide here. So our country has taken significant steps to improve the business and investment environment, particularly through the omnibus law on job creation. It was enacted back in 2020 by our previous president, Joko Widodo. And so this law plays a very important role to simplify the regulations and reducing bureaucratic red tape, which we were quite famous for that, unfortunately. But then, yeah, this law also becoming the basis of the establishment of the online single submission and risk-based licensing approach. So OSS system is the electronic licensing platform established by the BKPM, basically it's the Ministry of Investment of Indonesia, that simplifies the process to obtain business permit. So from micro enterprise, large enterprise, any business, banking, manufacturing, export, import, real estate, any business, you have to go through the online single submission to obtain your license. And the licensing requirement are highly depending on the business risk level. So there are 4 level categories: low risk, medium low risk, medium high risk, and high risk. So after the establishment of the company must sign up first to obtain the initial license, what we call an IB. Basically, it's the business number registration. And in general, there are 3 types of license, again, depending on the risk level. We have business identification number, the NIB, standard certificate, and licenses permits, depending on the sectoral regulations. And back to your question on special economic zones. It's actually a pretty big deal for foreign investors because special economic zones offer a smart and low risk way, I would say, for foreign investor to enter new markets in Indonesia, whether you're building hardware, data center, manufacturing. The advantages are quite real. Like, for example, the tax office rolls out a pretty generous tax deduction on corporate tax, and then friendlier dividend withholding, for example. And also, again, establishing the company in special economic zone also cut through a lot of red tape. In other words, you can get faster permits, easier custom clearance, and dedicated support teams to help you to set up the company. And most special economic zone are actually placed in prime spots, like nearby the airports, nearby the seaports, or industrial hubs. So this means better logistic for export imports. So the catch is, first, you need to be physically located in the official special economic zone, register the company through OSS system, and then apply for the incentives when you submit your investment plan. That would be my point, Ms. Pransu. Thank you.
Thank you, Ms. Jeany. Again, that was a detailed input. Now, moving on to the next slide and topic, recent developments, trade and economy, obviously concerning both the jurisdiction. I would call upon Ms. Jeany again to address a small brief questionnaire. How does the local currency settlement system contribute to lowering the legal and regulatory uncertainty in bilateral trade? Over to you, Ms. Jeany.
Yeah, right. So I think it's a very great initiative by the government to working on LCSS to facilitate the trade between India and Indonesia using the local currency. But how I see it from legal practitioners' view, I think the LCSS itself will not significantly alter the legal landscape on bilateral trade. Because why? Foreign exchange regulation and the trade laws in Indonesia are already relatively clear and established. But I think the main challenges to effective implementation are actually the operational and infrastructural readiness. Because for the LCSS to be truly attractive for business, I think the banks in both countries must be efficiently aligned and capable to handle the increase of direct currency settlements. Because if banks and payment platforms aren't fully integrated, for example, and they're not able to process transaction quickly, I think entrepreneurs will see greater risks and inefficiency. And additionally, I think the degree of proactive and feasible government support is also important, like a campaign by the central banks and both central banks in India and Indonesia, and also coordination between the institution. I think it's essential because without strong institutional backing, I think many companies might prefer the convenience and predictability of US dollar. Yeah. And I think I want to touch a little bit on the slide about BRICS. So earlier this year, Indonesia has joined the club with Brazil, Russia, China, and India. And I think it's very good because Indonesia then can tap into fast-growing economies across Asia, Africa, and also Latin America. And also the BRICS New Development Bank can help Indonesia with the project financing for infrastructure, for example, like roads, airports, seaports, and rail, for example. And also the other one, Pranshu, this is relevant to your previous question on the development of emerging technologies and digital infrastructure. During our president visit to New Delhi, he brought up the Ministry of Communication and Digital Affairs and signed MOU with the Ministry of Electronics and Information Technology from India for the development of emerging technologies like AI, IoT, blockchain, digital infrastructure. And I think this forum is a clear sign that both countries will accelerate furthermore on the digital growth, and hopefully it will bring real benefits for the economy. That would be my view, Pranshu. Thank you.
Thank you, Ms. Jeany. That was quite an updated insight into the topic. I would also request Mr. Das to kindly pitch in and enlighten our audience regarding the LCSS system concerning the Indian jurisdiction. Over to you, Mr. Das.
Thank you, Prashu. So I completely agree with Jeany. This step is a right step in a right direction, but it's a long way to go. We need to have the infrastructure ready. We need to have a very proactive government support for both the central banks, because at present, the current scenario is having a predictable timeline. Their efficiencies are already kind of checked and tested. These new things need some time to develop with a very robust system in place. Because if you are using SWIFT, again, you are using SWIFT, a system developed and controlled by those who are supposed to be outside this kind of currency settlement. So if we are talking of direct India and Indonesia settling in rupiah or rupee, we need to have those kind of systems in place, because then only you can control those systems. Otherwise, even if we are thinking that we are getting rid of this intermediary and any middleman getting out of the system, create efficiency, unfortunately, at present, I'm not seeing that happening. It needs to be supported in a way that we need to have a parallel system. Like in India, we do have UPI. So whether that UPI is getting extended to Indonesia, whether Indonesia is ready to accept that, and they have their security concern, their data privacy concern. So all those things are yet to be unfolded. So again, having said that, this is a right step in the right direction. In a long run, it will help both Indonesia and India. Because look, the more you are independently controlling the system, the more strong you feel about the business transactions. So it's a win-win for both the countries, but only time will tell whether we have just taken a step for the sake of, or for the heck of taking that step, or we are really serious. So time will tell. Again, to sum up in one line, it's a right step in the right direction. I'm pretty hopeful that it will go in a you can say, changing the scenario, the way India and Indonesia are doing their business. I'm just hopeful, and I'm wishing it should see the light of the day where we have started. And let's see. Pranshu.
Thank you, Mr.
Yeah.
Das. That was quite a practical insights into the existing framework. Now, let's move on to the next slide and next topic. Again, the IPOI, Indo-Pacific Oceans Initiative, IORA, that is Indian Ocean Rim Association, and the Blue Economy. I would call upon Ms. Jeany again to enlighten our viewers on what do you think it's more binding social and environmental clauses in trade agreement, particularly in context of Indo-Pacific Oceans Initiative and the Blue Economy objectives, that are whether they're desirable or not. Over to you, Ms. Jeany.
Yeah, thank you, Pranshu. So I think both Indo-Pacific Oceans Initiative and Indian Ocean Rim Association, IORA, I think firstly it's aligned with the Indonesia's Blue Economy Plan. So to leverage the ocean as a space of cooperation and not conflict. So just a brief context on Indonesia Blue Economy Roadmap. So we have this commitment to build a sustainable and resilient maritime economy because you know that our country with over 70,000 islands, we have a very vast ocean territory. We have a huge potential in marine-based industries, fisheries, aquaculture, tourism, logistic, even energy. But of course, we have real challenges, including inadequate capacity. So to answer your question, yes, stronger and binding social environmental clauses would be great and desirable, but only if they are drafted in a very clear scope. So Indonesia and India could agree to work on blue economy projects together, but again, from my view as a legal practitioner, investors want regulatory certainty, right? So not only trade deals like bilateral agreement, but it's important to making it in the clear domestic rules, which actually help businesses to operate sustainably. Like the trade deals can offer benefits like lower tariffs for eco-friendly goods or faster permits for low impact activities or tax reduction for business in green shipping or sustainable packaging. I think this would turn promises into real and practical advantage for entrepreneurs. That would be my view. Over to you, Ms. Pranshu.
Thank you, Ms. Jeany, again. That was quite insightful again. Now, moving on to the next slide and topic, diplomatic visit between the jurisdiction. I would request Ms. Jeany to walk us through the key points concerning the topic. Over to you, Ms. Jeany.
Yeah, so we have already covered the discussion before on bilateral agreements on trade and investment trends before, so I'll keep this one tight. So back in January 2025, our president made his first state visit to New Delhi and signed a joint statement with the Prime Minister Modi. And I think the statement sent a clear market signal to make business easier for both of us. And there are 6 priority sectors like healthcare, pharma, energy transition, like renewable, manufacturing, digitalization, like AI, fintech, and also food security. And the visit also produced some MOU, as we discussed earlier, on the digital economy, and then research and development for vaccination jointly between Indonesia and India, and then also hospital partnership, even cross lists on capital market side. So I think it's giving us signal that a longer term alignment between the countries. So I think the political door is wide open and the sector is clearly flagged. So we just really hope that the business will keep moving between the countries. Over to you, Ms. Pranshu. Thank you.
Thank you, Ms. Jeany. Now, moving forward to the next slide and a new topic, labor law and compliance for foreign businesses. I would call upon Ms. Maria to address the question to our viewers. Would you be able to provide us with the key requirements for employers in Indonesia when employing foreign staff? What are your views on that, Ms. Maria? Please, over to you.
Thank you very much for your question, Ms. Pranshu. This is indeed a very, very relevant topic when we're discussing about foreign direct investment in Indonesia. But I think before diving into the key requirements, I would firstly emphasize this. I think we need to really understand the spirit of Indonesia's manpower regulations, because while the countries is very, very welcoming in terms of foreign capitals coming to the countries and foreign expertise coming to the countries, but the spirit of the manpower law is actually to encourage, to prioritize the development of the local workforce. So I believe that when we're hiring foreign staff, it's not just about compliance issue, but it's also about strategic plan. I think this is really, really important for the company to assess more, because it's going to impact when the business gonna start operating in Indonesia, and then whether or not they can send their trusted personnel to take the position in their Indonesian companies, something like that. So that's very important to assess. And then also with respect to the compliance, it's mainly regulated under our manpower law, and then there's also the job creation law, and with additional layer of compliance to the sectoral regulations. So for example, if the company is in a financial industry, then there's these regulations provided by OJK, our Financial Services Authority, that you need to pay attention to. I think that's the overview, but now onto the core requirements. So the most important requirement, I think, is the Foreign Manpower Utilization Plan approval from the Ministry of Manpower. By the enactment of the job creation law, it obviously make the business licensing, not business licensing process, I'm sorry, but it's more like the licensing process in terms of hiring foreign workers. It get more streamlined because they trying to cut some of the previous requirement, and they're trying to like make it more simple to get more and more investors coming to Indonesia. So after getting the RPTK approval, they can go directly to the immigrations to process the visa. And I think what's important to take note is there's these restrictions in hiring foreign workers. First, the foreign workers can be only for a certain positions and only for a certain area of expertise, because there's these positions that are off limits for the foreign workers. For example, like HR positions, legal positions, or general administrations positions, and there's still a quite list under our manpower law. And then what to take note is that the foreign workers, they have to be a skilled worker. So meaning that they can only be hired if they're considered expertise. They have the certifications that showcasing their expertise in the positions that they're gonna be hired for, and then or at least they have the experience of at least 5 years in that position. And the foreign workers can only be hired for a fixed term under a fixed term employment contract. So it can be up to 2 years and for another 2 years extension. And despite all of the restrictions, the manpower law also trying to give like a special treatment when hiring a foreign workers, which is foreign workers can have dual positions. If a foreign workers is hired by company A as a hired by only or its sector. And lastly, I think this is the most important thing, back again to the spirit of our manpower law, which is to encourage the development of local workforce. It is important to note that the employer need to assign Indonesian workers for each of foreign workers that they hired. This is for transfer of knowledge, for education, and for training. I think that's the few for the key requirements in hiring foreign workers from me, Ms.
Thank you, Miss Maria. I believe I lost your voice at last. Sorry. Let's take this forward again. Thank you for that detailed insight into the realistic perspective and the scenario existing in Indonesia. I would call upon Mr. Tiwari next to answer a question related to the same topic. Given the new labor codes of India, how they affect the foreign companies entering Indian market, specifically concerning compliance and management of employees. Mr. Tiwari, over to you.
Yeah, sure. Thank you, Pransu. So, India's labor and employment laws have really undergone a change in 2019 when the government has introduced these four new labor codes. Earlier, there were plethora of laws in the field of labor and employment, but the government, in order to simplify the procedure and streamline the law, have codified the entire laws into four codes: the Industrial Relation Code, Code on Wages, Code on Social Security, and the Occupational Safety, Health, and Working Conditions Code. So these new codes have actually reduced a lot of regulatory burden from the employers. Because traditionally in India, the labor laws were regarded as a welfare legislation. The focus was basically on the workers or the workmen. But the new codes give equal protection to employer as well as the employee. So that way, it is giving some protection to employers as well. Um, one of the example is that initially for retrenchment, if it is more than 100 workers, you were required to take approval from the government. Now that threshold limit has been increased to 300 workers. Similarly, the fixed term contract employment has first time been mentioned in the labor codes. So that gives a kind of clarity in terms of employee management. So I think the reforms that have been brought about by the new labor codes will definitely instill confidence on the foreign investors as well, and they will feel more confident in investing in India. Yes.
Thank you, Mr. Tiwari, for providing a detailed overview of the Indian landscape. Now, moving on to the next slide related to the same topic again, I would like to call upon Mr. Das to address the questionnaire. With the rise of contractual workforce and fixed term employment, how do you see Indian companies balancing the flexibility and employee welfare in sectors like IT, manufacturing, etc.? Over to you, Mr. Das.
Thank you, Pranshu. So it's a tricky thing because company wants to earn more, all the company, and then to create a balance between the workers' welfare when the courts are now recognizing the employers as one of the big stakeholders. So Anil has already shared with 2019 development. Now there is a fair balance between the rights of employee and the employer. Earlier, it was heavily tilted towards the employee. But now the question rises because in India, the workforce is very mobile, and particularly for IT and such sectors, they need to have issue-based, assignment-based workforce. So that's why what they are doing is they are taking advantage of current scenario whereby they can have a fixed term contract, they can have a freelancer. So all those options these companies are generating with welfare as their tool. Why I'm saying welfare as their tool is because they are aware if they are not taking care of the welfare, these workers or these workforce, they will be migrating to some other companies. So even if whether they like it or not, this welfare thing is part and parcel of them retaining the real workforce because not all the people at the age of employability is actually having the quality to deliver. And when you are competing in a global market, you need to have employee base which carries a quality. And that's why companies are giving the remote working option. They are opting for female workforce, like Foxconn. They have set up a plant in Tamil Nadu. The major workforce there is females. So they are innovating with the current scenario to have the maximum efficiency without compromising on employment. You can employees welfare. So back to you, Pranshu.
Thank you, Mr. Das. That was again a very regionalistic perspective of the Indian jurisdiction that will definitely benefit our viewers. Now, moving on to the next topic and slide, employment contracts in Indonesia. I would call upon Ms. Maria again to address the questionnaire. That is, what are the key legal points in fixed-term employment contract between the employees and Indonesian employers that firm needs to factor in? Over to you, Ms. Maria.
Okay, thank you, Pranchu. I hope everyone can listen to my voice. It's a bit
You are
connection.
audible. Please
Okay,
proceed.
thank you very much. So just to provide a bit of context, under Indonesia's manpower law, there are two main types of employment contracts, which are fixed term contract and indefinite term contract. Fixed term contracts basically for the non-permanent roles, for a project base and for like a specific timeline or deliverables. And meanwhile, the indefinite term employment agreement, it's basically for permanent roles. Like what Ms. Pranshu asked earlier, that specifically for foreign workers, in this case, if Indian employees working in Indonesian companies, the employment has to be under a fixed term contract. And as I previously mentioned as well, so hiring foreign workers can only be on a fixed term, which is for up to 2 years and another extensions for another 2 years. And as shown on the slide, Indonesian law requires that all employment contract be made in writing and includes this specific list. So this is basically the foundational components that ensure the contract is legally valid. So this is the standard requirement to be followed. I think in addition to those, the most important thing that need to be paid attention to and needs to be included in the employment contract, fixed term employment contract, are first, there are no probation allowed. So make sure no provisions regulated such. And then I think it's very important to also clearly regulate termination process and the consequences. For example, like for early termination and what is the obligations and the rights for each party regarding such event. And then there has to be a clear mechanism on the dispute resolutions as well, and also the choice of forum, etc. And also, I think this is very, very important. It doesn't have to be included in the employment contract. It can also be referred, but a clear internal rules for a company is very, very important, especially when violations on such rules can lead or can trigger to a termination, because in a major cases, mostly what happened is this kind of challenge. The procedural related to terminations, and for example, like warning letters, should there be a warning letters, like how to escalate things until the termination happened. I think that's are the important things that companies need to pay attention to regarding this employing foreign workers and in creating fixed term employment contract. Thank you.
Thank you, Miss Maria. Again, that was quite an insightful analysis and enlightening too. Now, moving on to the next slide, and another topic of relevance: labor law dispute resolution mechanism. Now, Miss Maria, I would call you again to answer one of our questions related to this topic. How effectively has the bipartite and tripartite PPHI model worked in Indonesia's industrial dispute settlement? Over to you, Miss Maria.
Okay, thank you, Pranchu. I think before answering the question, we need to first understand that this model is first mandated by law, meaning that parties are required to follow each step in order until the dispute is resolved. And second of all, the goal of this approach is to encourage an early stage resolutions. So it does not have to be escalated to the court, because the legal culture in Indonesia is heavily value harmony, dialogue, and consensus. So I think this is the spirit of it. Now, in terms of effectiveness, I would say it really depends on the specific situation and the behavior of the parties that are involved. On the other hand, this structure can be very, very effective, especially when both parties are acting in good faith. It gives them space, like the bipartite and the tripartite stage. It can gives them space, time to engage with one another, find a common ground, find a mutual agreement, and further they can actually sign mutual separation agreement if they ended up in that decision. But in many cases, this really help them reduce time, cost, and preserving the work relationship. But on the other hand, one party is unwilling to cooperate, to comply, and to negotiate in good faith, I think the process can become very ineffective. And in such case, what they're aiming is just to go to the court. So overall, whether this layered structure is effective or not, it's really depending on whether or not both parties wants to cooperate in a good faith or not. I think that's my point, Pranchu. Thank you.
Thank you, Ms. Maria. Now, again, I would like to call on Mr. Tiwari to address a short questionnaire emanating from the same topic. In comparison with Indonesia, how about India's existing mechanism under Industrial Relation Code? If you can just provide a brief insight into that, Mr. Tiwari, over to you.
Thank you, Pransu. So, as mentioned by Ms. Maria, that under the PPHI system, there is an effort to resolve the conflict between the employer and the employee through mediation, through negotiation. Similarly, in India also, at the initial state, I mean, whenever any worker or the workman is aggrieved by any of the actions of the employer, he raises his grievance before the labor commissioner, and labor commissioner basically takes effort to settle the dispute through conciliation process. If that conciliation process fails, then the matter is referred to the industrial tribunal, depending upon whether it's a state industrial tribunal subject or a
Thank you, Mr. Tiwari. Now, let's move on to the next slide. The alternative dispute resolution, again, a topic of high relevance in current scenario. I would call upon Ms. Maria to address one of the questionnaire related to the topic. Can you describe the relative role of BANI, that is Badan Arbitraries National Indonesia, and Indian arbitration authorities such as MCIA or ICA in settling the FDI related disputes? Over to you, Ms. Maria.
Thank you, Ms. Pranchu. So I think either BANI, MCIA, and also the ICA, sorry, they all are commercial arbitration institutions. But their role, I think it's really depending, but their role in cross-border dispute, yeah, especially in the context of foreign direct investments, I think it really depending on what agreed in the contracts. So I would like to emphasize that it is very a well-drafted arbitration clause in your contract. And it should clearly specify the clause in details. So in Indonesia itself, there's BANI, the Indonesian National Board of Arbitrations, which is a leading institution for commercial arbitrations, and it's operate under the law number 30 of 1999. And it is often like the go-to body for resolving dispute involving foreign investor, provided that the party have included the BANI clause in their agreement. And another options for commercial disputes within the financial services sector like fintech or banking, there's also this arbitrations institution called LAPS SJK, which is an arbitration institutions for financial sector, which is recognized by our Financial Services Authority or OJK. So it can also be another options. So back again, I think both of BANI and also LAPS SJK can be available options, and it's really depending on the type of the dispute, and it's depending on whether which forum that both parties are more comfortable to choose, and it needs to clearly draft it under your contract. I think that's the point from me, Ms. Pranchu.
Thank you, Ms. Maria. Now, Mr. Ashutosh, I would just like you to provide a brief insight into, as per Ms. Maria explanation earlier, do you think MCIA and ICA have the same role as BANI? Over to you, Mr. Das.
Yeah, I'm kind of mindful of time, so I will be really brief. So from an Indian perspective, the Indian Council of Arbitration, ICA, is functionally similar to BANI, both being institutional arbitration bodies, and they are offering dispute resolution service under a structured rule. So though we do have the Mediation Council of India now after 2023, and it governs mediation, a separate non-adjudicatory ADR process. But BANI and ACA is aligned more closely in terms of role and structure, whereas MCI represents India's shift towards formalizing mediation. So back to you.
Thank you,
Bang on
Mr.
time.
Das. Thank you for keeping the timeline in mind. Now, Ms. Maria, just a short running reference, if you can provide us, what are the best practices in preparing the enforceable ADR clauses for India-Indonesia investment cross-border agreements? I would request you to please keep it brief. Over to you.
Yeah, thank you, Ms. Pranshu. So, like what I mentioned before, it has to be clearly and precisely drafted, right? So yeah, for Indonesia and India, I think arbitration would be the preferred method because both of the countries are the signatories, right, to the New York Convention. But I think what's important to explicitly specify in your ADR clause is that you have to be clear about the seat of arbitrations, whether you choose Bani Jakarta or like ICA in India or MCI Mumbai, and then the institutional rules, for example, are you going to choose the Bani rules or are you going to choose the MCIA rules or the AAA rules, for example? And specifying both the forum and the applicable rules, the governing law of the contract, the language of arbitrations, etc., that are important to be written in a clear manner in your contract. And as a corporate lawyer, I always emphasize this to our client. So if the Indonesian party is involved, and especially if the assets or commercial activities are located or significantly conducted in the jurisdiction of Indonesia, it is often more practical to choose Indonesia as the seat or the choice of forum for arbitration. So why? Because this increases the likelihood of a smooth enforcement and helps to avoid unnecessary procedural hurdles under our local laws. So yeah, I think that's the important point that need to be taken. But also please note that when we're dealing with cross-border transactions, there will always be a risk. So this is our effort to minimize the risk, but please also remember that the risk will still remain. I think that's a key point from me, Ms. Pranshu. Thank you very much.
Thank you, Miss Maria. Again, thank you for keeping it short, brief, and insightful yet. Now, moving on to the next slide, one of another highly relevant topic that we come across for enforcement of foreign judgments. I would call upon Mr. Tiwari to kindly run us through the ways, in what ways does India and Indonesia differ in enforcing these foreign arbitral awards, and what are the cross-border contract implications, if you can enlighten our reviewers, please? Over to you, Mr.
Thank you, Pransu. So India is signatory to New York Convention and Geneva Convention. So under the border framework of these two conventions, the foreign awards are enforceable in India. And in 2015, the India Arbitration Conciliation Act has undergone a significant change. And as per the amended act, section 46, 47, and 48 deal with the enforceability of the foreign award in India. So what are the basic requirement for enforcing a foreign award in India? The first is the authenticated copy of the foreign award, the evidence that the award is a foreign award, and the authenticated or the original copy of the award. So these are the basic requirement with which you can apply before the jurisdictional high court for enforcement of the foreign award in India. And the rejection of the foreign award is on a very minimal ground in India. Like if it is found that the parties to the agreement were incapacitated, or proper notice to the other side was not given, or if the award is against the public policy of India or against the basic principle of justice. Only on these limited grounds, the foreign awards are rejected. Otherwise, the foreign awards are enforceable in India. In Indonesia, on the other hand, I mean, the foreign judgments are basically having only evidentiary value. However, Indonesia has also signed a New York Convention in 1981, and after that, the foreign awards in Indonesia are also enforceable. Um, In Indonesia, the enforcement of the foreign award is done basically through Central District of Jakarta, and it has to be done within 30 days of the passing of the award. So yes, now provision has been, I mean, in Indonesia also the foreign awards are very much enforceable. Yeah,
Thank you,
that's all.
Mr. Tiwari. Thank you for keeping it short yet detailed explanation. I would call upon you again as we move towards the end of the session. Can you enlighten our viewers about the dispute resolution and ADR mechanism in bilateral trade between both the jurisdiction in a brief so that we can conclude this session? Over to you,
Yeah.
Mr. Tiwari.
So, as mentioned by Ms. Maria also, that having an unambiguous and a clear dispute resolution clause in an arbitration agreement is of pivotal importance. And as the cross-border agreements or the cross-border trade is increasing every day, the importance of the alternate dispute resolution as a dispute resolution mechanism is gaining momentum and is going to play a very important role because ADR provides a speedy, cost-effective mechanism for the dispute resolution, and that way it provides stability to the business. It gives confidence and trust to the foreign investors in investing in that particular country. So that way, the alternate dispute resolution is the way forward, and that is why it is there in most of the cross-border agreements. Uh, so far as India and Indonesia are concerned, the most of the trade agreement have these ADR provisions like in India, Indonesia BIT agreement. It provides for dispute resolution framework that includes arbitration as a final resort. Similarly, the ASEAN India Free Trade Agreement also provides resolution of disputes through consultation, panel reviews, and arbitration. The DTAA, Double Taxation Avoidance Agreement, also provides for resolution of disputes through mutual agreement procedure. And I feel that the comprehensive economic cooperation agreement should also provide similar provision for resolution of disputes through alternative mechanism, and that will really encourage the investors in both the countries. So that's all, Pranshu.
Thank you. Thank you, Mr. Tiwari. Thank you to all the speakers. So, by this, we come towards the end of the session. We acknowledge the participation of our viewers through the YouTube platform. However, again, due to paucity of time, we won't be able to take the questions right now. However, we'll be reverting to those questions through the concerned platform. Now, thank you to our esteemed panelists for their insights and to our audience for their engagement. Today's discussion highlighted the immense business opportunities existing between both the jurisdiction India and Indonesia, importance of cross-border collaboration also, and we hope this session provided a valuable takeaway for all your ventures. Wishing you all the success. Thank you so much. And with this, we end this session. Thank you.
Thank you so much,
Thank
Pranshu.
you, everyone.
Thank
Thank
you,
you, everyone.
everyone.
Hmm.